Hello again, it's Dan with the Law Offices of Daniel Hunt, and in this video today we'll be discussing what happens to your estate plan if you move out of the great state of California. You may wish to be moving closer to family, maybe you got a new job, or maybe you're retiring. So does that mean that you have to completely redo your entire estate plan? Probably not, but it might be a good idea to have it reviewed by a local attorney where you move. So in this video, we'll be talking about the most common components of an estate plan and if they should be reviewed or replaced if you end up moving out of state. If you haven't created an estate plan and you are spending time in multiple states, it's probably a good idea to have your estate plan drafted in the state where you spend most of your time or where most of your assets are located. If you already have a California Revocable Living Trust, it's going to be good to no matter what state you move, with the exception of Louisiana. Louisiana has some interesting laws, and you'll definitely want to speak with a local attorney if you end up moving there to ensure that your trust is still good in that state and will reflect your desires when you pass away. For other states, if you purchase a home there, it's important to make sure that you title your home into your California trust when you move there. If all of your assets are primarily going to be located in that new state, it may be a good idea to discuss this with a local attorney, whether it's more appropriate to retain your California trust or to create a new trust under the laws of that new state. So what about your last will and testament? It's probably a good idea to have a new last will and testament drafted if you move to a new state. The reason being, probate courts have very specific rules as to who can serve as the administrator of your estate. For example, in Florida, the person has to be related to you or a Florida resident. If that person isn't related to you and is not a resident of Florida, they likely will not appoint your administrator that's named in your will to be the executor of your estate. So while your California will may technically still be valid, it may create more hurdles for the administrator or executor of your estate to where you move. Also, it's important to understand that laws have very specific rules on the execution of wills. So they may not feel that the California will, which was executed here, was duly executed under their laws. So what about your advanced healthcare directive when you move to a different state? For convenience, it's probably a good idea for you to consult with a local estate planning attorney with regard to your advanced healthcare directive and whether that will be usable to wherever you move. There can be significant variance in the terminology that is used in these documents as well as the laws that they are drafted under. In addition to that, it may be that you lived very close to your agent when you were here in California, but you've moved away, and it's a good idea to have an agent that's accessible and close since these decisions many times are being made in an emergency situation. Your durable power of attorney. So if you have a durable power of attorney and you move to another state, it likely will be upheld in that state. It is still a good idea to have it reviewed by a local attorney and make sure that it's going to be valid there the way it's drafted under California law. Also, it might be a good idea for you to take that to your bank and ask them if they will honor the California power of attorney for an agent who comes to use it at their bank. What about beneficiary designations? Beneficiary designations on things like your life insurance or retirement accounts are valid no matter where you live. That's an agreement or a contract between the life insurance company or your retirement provider that when you pass away, they're going to give that money to whoever you've designated as the beneficiary. There's no need to update those. So in conclusion, most of your estate plan will remain valid if you move out of California, such as your trust and your power of attorney, the trustees that you've appointed, and the beneficiaries that you have designated on your retirement accounts and your life insurance. But other documents like your will and your advanced directive, it's likely a good idea to have those documents updated. We recommend that you seek the advice and counsel of a local estate planning attorney wherever you move to. If you have any other questions with regard to anything we've discussed in this video, please contact us. We look forward to working with you. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.